Right, good afternoon everyone. Thank you for coming, and it's a pleasure to be here. Thank you for the Institute and Professor Stychin for the invitation to come and share some of the insights or the thoughts that have resulted from research that I've been carrying out, as you've heard, on the administration of justice by non-state armed groups in a variety of contemporary armed conflict. So I thought today it might be of interest in the context of the UK to have a 100% Brexit-free discussion of the way in which the British stance regarding its own citizens that have gone abroad to join ISIS and its apparent refusal or lack of enthusiasm for its nationals to come back home, what the implications are under international law vis-a-vis the possibility that these fighters be handled or dealt with abroad. Now, in the news, I think is Shamima Begum has been the most famous of these fighters. No, she wasn't a fighter, but these ISIS supporters who've left the UK. But there are a range of others. You might also have heard of Hamza Parvez, who also is a British citizen who joined to become a fighter with ISIS and is still is held in Syria. The Kurds in both Syria and Iraq detain thousands of ISIS fighters as well as sympathizers, and it is said that they hold more than 1,000 foreign fighters from more than 50 different countries. In addition to fighters, they hold a large number of relatives of these fighters. The fighters are often all men. So wives and children or other relatives of fighters. The Kurds have asked all the countries of origins of these fighters to take their nationals back. So the Kurds do not want to have to deal with these people. And many countries, like the United Kingdom, are, shall we say, less than enthusiastic at the prospect of welcoming home their nationals. So there are a number of countries that have expressly made statements to that effect, including my home country, Canada, but also the United States has been ambiguous about it, saying that people should take them back, but so far they haven't wanted to take back the one person that has been in that situation, and some of the countries as well. France is an interesting case in that respect. Up until recently, up until January, its stance was also that it did not want its own nationals back, but it seems to have changed its position officially to decide that they should be welcomed back and then dealt with either through prosecution or through administrative measures once they have returned to France. And I think that France probably is the country with the largest group of ISIS fighters amongst the Western states. One strategy that is illustrated here has been denationalization. And this, a number of countries have attempted or adopted a position of taking away nationality of nationals who've gone to join ISIS as a way of cutting links with that individual and therefore preventing any argument that those individuals should be welcomed back. So this has happened not only with respect to Shamima Begum, but also to citizens in Australia, as well as the United States, where again there are disagreements as to which nationality the person has. It is, of course, not an option for many of the fighters who do not have another actual or putative nationality. I believe Hamza Parvez, for example, was born in the UK and does not have another nationality that can be imputed to him by the UK government. There are human rights rules that prevent withdrawing nationality that results in statelessness. And there are other human rights rules. There's a human right to have access to one's own national territory. So states, in theory, are not in a position to prevent one of their own nationals from returning to national territory. But of course, that implies that that individual has managed to make it to the border. Whether the state has an obligation to provide assistance in getting their national from wherever they may be to the national border, well, that is much less clear under human rights law, and the practice of governments has been often to deny that they have any such obligation under international law. At any case, they may have obligation pursuant to the domestic law of various states. So, if the UK and others do not want to have people like Hamza Parvez and others, what then are the options? And so there are a number of options, and I'll say a few words about each of them so as to provide the context for the possibility of Kurdish trials, on which I will say more. So you have here a number of options. I didn't actually count them. Seven options that might be thought of as possibilities of what to do with ISIS fighters from the UK. The first is the International Criminal Court. And there seems to be very limited possibility of seizing the International Criminal Court, given that neither Iraq nor Syria are parties to the statute. There could be a possibility through the nationality of the perpetrator, or referral from the UN Security Council seems politically unlikely given the Russian government's support of the Assad regime. There has been some movement, I think including some movement based in London, to provide information to the ICC, relying on a recent decision by a pretrial chamber related to the persecution of the Rohingya in Burma, in which the ICC has found that because of the transnational nature of the crime of forced deportation, despite the fact that the individual were initially mistreated on the territory of a non-state party, Burma, they came to Bangladesh, which is a state party, and deportation is a type of continuous crime. And therefore, the pretrial chamber concluded that it could have jurisdiction. So apparently, there were some Article 15 communications, as they are known, to the ICC prosecutor by Syrian refugees in Jordan, which is a state party to the ICC statute, to the Rome statute, trying to make the same argument, essentially. To say that Jordan's ratification of the ICC can be stretched over the border and include crimes committed in Syria that carry over, that have a transnational component, like the situation of the Rohingya in Burma. There are few limitations. In this, the first is that the decision itself related to the Rohingya is a pre-trial decision that is likely to be contested and revisited if this decision moves forward. It was a relatively daring stance adopted by the ICC pretrial chamber. Much depends on Jordan. In the case of the Rohingya, the stance of the government of Bangladesh, which supported a referral to the ICC, played a significant role in the conclusion of the ICC pretrial chamber. Here, it would depend on what the government of Jordan does vis-a-vis such communications. And finally, I haven't been able to have access to these communications, but from reports that I've seen, they mostly seem to be directed at the Syrian government, much more than ISIS. And so they may open a door for an ICC prosecution related to Syrian governmental persecution, but it's harder to see how we get to ISIS and ISIS fighters in that respect. So the ICC is not impossible, but there are significant obstacles that stand in the way of turning to the ICC. A second possibility is the creation of a hybrid or internationalized tribunal, similar to what we've seen in Sierra Leone with the Special Court for Sierra Leone, the ECCC, the Extraordinary Chamber of the Courts of Cambodia, the Special Tribunal for Lebanon. There are a number of others. I think the most recent is the Central African Republic Special Chamber, in which the United Nations has collaborated with a national government to establish an ad hoc institution. The Kurds in both Iraq and Syria have specifically requested the creation of such a tribunal. As part of this project, I did fieldwork in Iraq and had the chance to sit down with the Kurdish foreign minister in Iraq. And they took a very nice picture that I just wanted to show off. It's a very grand meeting. Really a key point that the foreign minister wanted to put across was how much they wanted a hybrid tribunal created. In the context of Iraq, it was particularly to deal with the crimes against Yazidis. This was their thrusting point with the international community on the need to react to the apparent genocide against the Yazidis, to push for the creation of a hybrid tribunal that would deal with ISIS fighters more broadly. The Kurds in Syria, and I should have specified that these are two different entities. In fact, they don't like each other very much. The relationship between various Kurdish groups is actually very complicated, and in spite of the fact of having a common enemy in ISIS, the Kurds in the Kurdish region of Iraq are allies of Turkey traditionally, which is an enemy of the YPG in the Kurdish group in northern Syria, which the Turks consider to be an alter ego for the PKK, the Kurdish insurgency in Turkey proper, which is in fact based in Qandil mountain in northern Iraq. So there is a sort of a chassé-croisé of relations that is moving and not easy to figure out. But in the request for hybrid courts, the Kurds in Iraq and Syria do converge, whether it be a joint court or separate courts. They do actually want it. There seems to be zero enthusiasm, as far as I can tell, amongst governments in creating such a court. And there was a statement just a couple of weeks ago by the US envoy to Syria, who was asked about a hybrid court, and his statement, I quote, "We're not looking at that right now." So, pithy statement that I think well, speaks to the general lack of enthusiasm of the current US administration for multilateral institutions in this area, but more specifically for the possibility of a hybrid court there. I know of no government that has expressed support for that. There might be some, but I haven't come across any. So, not a great possibility. Then transfer of detainees to the local government in Iraq and Syria. So the Syrian Kurds have actually transferred a number of fighters, in a few hundred, to the government of Iraq. So the Syrian Kurds have transferred ISIS detainees to Iraq. And the Iraqis have prosecuted, I don't know all, but they prosecuted a number of these ISIS fighters, and the Iraqi government in Baghdad says that they are willing to receive more in as much as they are connected to crimes committed in Iraq. Okay, so as you may know, the caliphate proclaimed by ISIS erased the border between Iraq and Syria, so that there was free-flowing movement of ISIS fighters. So it offers somewhat of a solution. Amongst these fighters are at least a couple of foreign fighters from Western countries. There are two Belgian nationals, one of whom was convicted and condemned to the capital penalty last summer, and the second one just a couple of weeks ago was convicted and again condemned to death by the Iraqis. Of course, there are problems with that. Chief amongst them, from an international law perspective, is the severe shortcoming in due process for those accused of terrorism activities before Iraqi courts. There was a recent report a couple of months ago that found that the average terrorism trial before Iraqi courts is 2 minutes. And the conviction rates upwards of 90%, the death penalty, I think 80% of those. If the defendant has a lawyer, the average time goes up to 4 minutes. And I don't have precise statistics as to what the conviction rate is. So all that suggests that there ain't a lot of justice before Iraqi courts. And as we know, the transfer towards a system in which there are severe shortcomings in due process is itself a human rights violation. And so this as an approach that could be encouraged would be highly problematic. So it would be highly problematic for the UK government to advise another entity to carry out a human rights violation. Essentially, that is a serious one, resulting in the possible death of the people targeted. So this was kind of a diagonal transfer from the Syrian Kurds to the Iraqi government. Two other options. Then the Iraqi Kurds to the Iraqi government. I'm unaware that any such transfer has taken place. My sense from being in northern Iraq and speaking to a Kurdish official there is that there is a very rigid barrier between Kurdish Iraq and the rest of Iraq And there is no official Iraqi central government presence in northern Iraq, in the Kurdish region of Iraq. When you land at the airport, it's a Kurdish official that stamps your passport. And there is no cooperation between the Kurdish judiciary in the Kurdish region of Iraq and the judiciary of the rest of Iraq. There are theoretical links that are permissible under the Iraqi constitutions, and you can take a case and appeal it to Baghdad. That, as far as I can tell, does not happen. There is no recognition of judgments in the rest of Iraq of Kurdish judgments. They're treated like a foreign judgment. They're in a different language in any case. And so that suggests that it seems quite unlikely that the Iraqi Kurds would want to transfer their detainees to the central Iraqi government. My assessment of the courts of the Kurdish region of Iraq is that whilst they're not perfect, they seem to be a very significant improvement as compared to the Iraqi government courts. Okay, so far for me to say there are no problems, but really we're not talking about the same kind of operation at all. Okay, there's much more justice to be found, in my mind, in the Kurdish courts in Iraq and in the regular government court of Iraq. The transfer of ISIS detainees by Syrian Kurds to the Syrian government does not seem like something that has happened, nor that seems likely to happen. As I'll come to in a moment, the relationship between the Kurds and the Assad regime is very difficult to figure out. But so there is a coexistence of sort in some respect. But that does not seem to extend to the administration of justice. In any case, if there are severe problems with due process before Iraqi government courts, there are even more problems of fairness before Syrian government courts. So the same issue would arise. I think anybody transferring willingly anyone towards the Syrian court system, the official court system, would be in violation of human rights obligations. So that doesn't seem to be a realistic possibility. Okay, transfer to indefinite detention. That's another option. Just keep them locked up. Many governments seem happy enough to have their nationals just stay where they are and not dealt with. That may be fine from an international law point of view, at least, up until the conflict continues. This is a disputed legal issue, but there is significant support for the view that even non-state armed groups have the legal power to detain enemy fighters during an armed conflict. And this is not accepted by all governments, but for example, the International Committee of the Red Cross, in its very recent commentary of the 1949 Geneva Convention, now adopts this position. So it is possible while the conflict is ongoing. Now, the conflict in Syria seems to be winding down, the active phase. The conflict, of course, there are probably multiple conflicts. So if you consider that there was a conflict between ISIS and the Kurds, or between ISIS, the Kurds, and the Syrian government as one conflict, that seems to be calming down. we seem to be coming to a general close of active hostilities anyway. Then Turkey has an armed presence in northern Turkey, so there is a belligerent occupation there. That seems to be a distinct conflict, but again, these are characterizations that are subject to challenge. All that to say that, in principle, when the conflict ends, the legal foundation of detention under international humanitarian law ends as well, or is expected to be completed. So there is kind of a sunset to this possibility of lawful detention of ISIS fighters, whether from the UK or from anywhere else. After that, well, it becomes an arbitrary detention as that is defined under human rights law. So at some point you have to have a legal foundation for continued detention of an individual. And if they are going to be detained for terrorism or crimes committed as ISIS fighters, then that implies some kind of trial and some kind of pronouncement. We'll come back to that for the Kurds. Setting them free. That's another option. And when the United States announced that, when President Trump announced that, they were done and they were pulling out, apparently to the surprise of much of his administration, the reaction of the Kurds was, one of the things the Kurds said is that, fine, we'll just let them all free. All the ISIS fighters free. You're going to go fight. And they're just going to expel them from their territory. Of course, that would be a problem. There would be an enormous security risk, including for foreign fighters from places like the UK, because the risk is that all these people start showing up at the border, and then they become a national security risk domestically in all countries. More generally, there would be no accountability and no justice with respect to the crimes that some of these fighters would have committed, and so that doesn't seem to be an ideal solution. We should note that the Kurds in Syria have, in fact, released a number of ISIS supporters. So people who have had connections to ISIS, but not necessarily as combatants, but local administrators, whatever, in areas controlled by ISIS, many of those have been set free by the Kurds, just because they have other problems to deal with. Even for fighters, the Kurds in Syria have released at least 80 ISIS fighters. And basically as part of an attempt to foster better relations with Arab communities in areas that are now under the control of the Kurds in Rojava, in northern Syria. So political calculation. And so there have been some amnesties for straight political calculations. So that has happened, but a relatively small number of fighters have been released. The last option is local trials. Now, local justice is the default recipe for any kind of crime. And, local law is applicable to the trial as it was to the crime. There's better access to the evidence, there's greater interest in prosecution. So in general, it's thought to be preferable for individuals to be tried in the location of the crime. Of course, in the case of Syria and Iraq, the local trials by the government is not thought to be highly desirable by foreign governments in the case of Syria, or by the Kurds that detain many of the ISIS fighters in Iraq for the case of Iraq. And so the question then becomes, when we say, well, normally local trials are preferable, do you mean necessarily local trials by the government? Or could that mean local trials by other entities that are not governments, like the Kurdish entities in Iraq and Syria? So what are the implications of that? So I'm going to turn now to the administration of justice in the Kurdish region of Syria. I can talk also about Iraq. If there are questions later, if you're interested in that as well. My sense is that the debate in the UK has been more about Syria than Iraq, so I'll speak more about what is going on in Syria. So as I mentioned, this is part of a bigger project that I'm been carrying out for the last 4 years on the administration of justice by non-state armed groups. And this is a practice that is quite prevalent, but that has received very, very little attention by both legal and non-legal scholars. So we don't know much about it. We know that it happened, but we don't know much more than that. So part of the project that I'm carrying out is to map out that practice with a number of key case studies, including so you have here the LTTE courts, Tamil Tiger courts in the northeast of Sri Lanka. They had a very elaborate court system. The FARC here also administered justice in zones either under the control or under their influence for the decades of the war in that conflict. Here you have a photo of a courtroom run by ISIS. So ISIS itself had its own court and its own administration of justice that I'm also studying. There are others, including the Taliban in Afghanistan, the Polisario Front in Western Sahara, and the Kurds. And there are more, right? But those are the cases that I've studied, and I've done field work in Iraq on the Kurds and ISIS, in Colombia and in Sri Lanka. Now, as far as Syria is concerned, so Syria, so the north of Syria has started to gain autonomy from the beginning of the civil war, but a real form of local governance starts to emerge only in 2013. And in 2014, I'll refer to it as the Rojava administration, the name of the region. It's dominated by the Kurds, and the YPG are the armed forces associated with the Kurds, although there are other participants in that. There are junior participants. The Kurds really are the ones that have control over Rojava. And very interestingly, in 2014, Rojava proclaimed itself a subnational entity of Syria. So this is very strange. I don't know of any other example of an entity that unilaterally declares itself a subnational federal entity. This is contrasted to the Iraqi Kurds, who, you will remember, had a referendum in September 2017, and that referendum aimed to outright independence of the Kurdish region of Iraq. And this is the more familiar one that we've seen in Scotland, Quebec, Catalonia, and so on. Here, the Syrian government does not accept that it is a federal state, which is very, very odd. But whatever. So they don't want independence. And then the reason why, is Turkey. Turkey is the whole explanation. The sense was that if the Syrian Kurds tried to declare independence, they would be immediately invaded by Turkey. And so that's why they didn't quite go that far. They, in 2014, adopted what they call, interestingly again, the social contract. So very Rousseau way of thinking about constitutionalism. The social contract is basically the constitution of Rojava adopted by the Kurds. There has been, as I mentioned earlier, de facto autonomy from the central government in Damascus. So Rojava operates autonomously, but there is a significant presence of the Damascus government within the area, within Rojava. And so this is unlike Iraq, where, as I suggested, what I told you earlier, in the Kurdish region of Iraq, you will not find a Baghdad official. They're not there. Okay? In Rojava, in Syria, on the contrary, there are many officials that are getting their salary from Damascus while operating in Rojava. So the social contract includes a Charter of Rights and Freedom that has everything a human rights lawyer would wish to find in a constitution. It abolishes the death penalty, which remains applicable in the rest of Syria. It's very big on gender equality. So you might have seen the photos of the YP, I forget the acronym, from the women's pendant of the YPG. So the armed forces are composed of men and women. And so it's a very progressive document in many ways. One important thing that you will find in the social contract, so the constitution of Rojava, is the principle of the independence of the judiciary. So all sorts of good things in there. This is supplemented by a sophisticated court structure in Rojava, and I'm still always describing things created by the Kurdish non-state armed group. So they have a constitutional court, they have a people's court that is the main court in Rojava. The people's court has both a trial division and an appeals division, so it's like a high court equivalent for Rojava. It also has military courts that deal with offenses committed by people connected to the armed forces. It had special anti-terrorism courts that would have dealt with people like ISIS fighters. Now, it's been reported that those anti-terrorism courts have merged into the People's Court. But, as with everything dealing with Syria, it's really difficult to have access to reliable information. So, that's apparently reliable information suggests that there's been a merger back into the regular courts, but I say that with a grain of salt. The Assad regime in Damascus completely rejects the legitimacy of those courts, and there it's not ambiguous. So there's no cooperation in that respect. So for the Syrian government, this is all illegal. and of no validity at all. Applicable law is hard to gauge again. It seems that the Syrian law is kind of the starting point, unless they don't like it. And if they don't like it, then they look elsewhere. So Swiss law, British law, German law, Egyptian law, whatever. Whatever seems good. Customary law also plays a significant role. And part of the issue seems to be that this seems to be quite unclear, fluid, and variable. So depending on where you are, who's the judge, so different bodies of law seem to be, put into the mix. So a bit of an issue there. So this is the system that would be in charge of British fighters like Hamza Parvez. If the UK says, they should be dealt with locally, that's what locally looks like. Okay. So, what can we think about that? Is the British government doing a blatantly illegal act by pushing its own national towards a system like that? So, there are, we can say, three things related to the legality of the courts, to due process, and to applicable law vis-à-vis these Syrian Kurdish courts. So, are these courts legal? I mean, they're illegal under Syrian law. There's unambiguous about it. So these are marked by total illegality. And this is the way in which lawyers would tend to think about such things, right? Rebel groups are outlaws, and so the idea that outlaws might create courts is just kind of an oxymoron or a contradiction, and there's no legality to be found there. This is the position of pretty much any government that is confronted with that kind of a practice, right? So the IRA had its own courts, and the British government didn't think that these really were courts in any real and meaningful way. ISIS had courts, and it's useful to mention ISIS because we are exposed to a discourse on ISIS, we in the West, are exposed to a discourse on ISIS that's very similar to the discourse of local governments in, Sri Lanka vis-à-vis the LTTE, in Syria vis-à-vis ISIS and the Kurds, in Colombia vis-à-vis the FARC. Locally, all these people were described in pretty much the same way that ISIS is described in media here, bandit terrorists, crazies. And so, from a local perspective, this is the same as talking about the courts of ISIS, which is important for me to have ISIS as one case study, precisely because it kind of strains credibility to suggest that there might be justice. And there are differences between different courts. So, is it possible? Is there a legal foundation, not in domestic law, but in international law? And basically, the answer is that, well, there's an argument to be made that's really not the worst argument that you can imagine. So, in situations of war conflict like Syria and Iraq, so you'll have Common Article 3 of the 1949 Geneva Conventions that is applicable. And one of the things it says is, so it prohibits the passing out of sentences and the carrying out of executions without previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized people. So the key segment here is this expression, regularly constituted courts. And up till very recently, this was taken to refer to regularly constituted under the law of the state. Okay? And in 1949, this was put into the Geneva Conventions in order to criminalize or render illegal summary executions in times of war. And you might know that Churchill was in favor of summary execution of the Nazi leadership. Stalin was even more ambitious. He thought 100,000 Nazis summarily executed should do the job. And eventually they were convinced to create the International Military Tribunal in Nuremberg instead. So this was what it was meant to address. So that seemed to make it difficult to apply this to courts of a non-state group. This article, Common Article 3, so which applies to non-international conflict, was supplemented in 1977 by additional Protocol 2 to the Geneva Conventions, and it says in the equivalent provision, so no sentence passed and no penalty, blah blah blah, except pursuant to a conviction pronounced by a court offering the essential guarantees of independence and impartiality. So, what's not there? What's not there is the reference to a regularly constituted court. So this is a critical omission, which was intentional. And it opens the door to say that the evolution is meant to recognize the practice of non-state armed groups in establishing their own courts. And linking legitimacy and the due process guarantees that are actually offered by such courts. David Luban, a legal theorist, once spoke about, in an article, this was from rightness through fairness, was the way that he put it. Courts are right if they are fair. And this is the approach that we see embodied here. If courts can operate fairly, then they can be legitimate. And we see something like that, again, in a somewhat contradictory way in the Rome Statute of the International Criminal Court. So, unfortunately, it's not as clear as it could be. So, in the actual Rome Statute, Article 8.2c4, still refers to regularly constituted court. So this is 1998, so we go back to the 1949 formulation. But in the elements of crime adopted pursuant to the Rome Statute, a regularly constituted court is described as a court that provides due process. So there we have the other version. Where independence and impartiality and the rest of the process provides legitimacy. So this is a somewhat conflicting approach in the ICC regime, but whatever. It offers a possibility that that such court might be legal. This was interpreted in a very important case. Before the Swedish courts, dealing with a man called Hassam Omar Sakan. And Sakan was a Syrian who had come to Sweden and claimed refugee status. And after several years, his claim was accepted. He was a refugee living in Sweden, and a video appeared on YouTube in which he was shown killing some men. And this is a still photo from that video. And you see at the end Sakan very clearly. And later in the video, he shoots and kills the man on the ground in front of him. I haven't looked at the video. I don't look at those videos. I advise you not to either. but apparently that is, there's no doubt from an evidentiary point of view that he participated. And so he was arrested and accused of war crime. And in his defense, he didn't deny that it was him, that he shot and killed the man on the ground. What he said was that I was part of an execution squad. And these men had been judged by a court created by the Free Syrian Army, not the Kurdish Syrian Democratic Forces, so Free Syrian Army, and they had been judged and found guilty of murder and rape. They had been government soldiers that had committed these crimes in a battle a week before, and they were condemned to the death penalty. And I just happened to be in a unit around, and I was designated as a member of the firing squad, and so I did. And so this puts the Stockholm District Court in the awkward position of having to decide whether this was a legally viable argument to make. And the court, the decision is in Swedish, and so Google Translate, only gets you so far. There's a bit of it that's been translated. But as far as I can understand, so the court accepts the claim, the basic claim that a group, a rebel group can create its own cause. So it's quite a remarkable finding. And it finds that in that case, the trial was completed in, they were arrested, accused, tried, condemned, died, and execution all over a 24-hour period. And the judge finds that this is simply too short a time for meaningful due process. And that, therefore, the court perhaps was created validly, but it wasn't a fair trial. And because of that, Stychin was convicted of homicide. And there was a disgap in the sentence because of the circumstances, but he was still convicted. So we have at least this decision. So it seems that there is an argument to make that the Syrian Kurds can create these courts that I described earlier. Now, what are these due process requirements? What is it that they must do in order to avoid what Stychin faced and being told that they acted unfairly? And Additional Protocol 2 from 1977 does list a basic human rights standard, including the right to a full defense, nullum crimen sine lege, presumption of innocence, the right to be present, protection against enforced testimony of the accused. And so there is a kind of a short list that is much shorter than what you would find in human rights, like in the International Covenant on Civil and Political Rights, for example, as sort of the minimum for due process. As I said, in Stychin, the court found that there was not such due process. In the Syrian courts, it would have to be assessed. And again, this is quite difficult to assess, for example, the degree of independence, the right to a lawyer. Apparently, often the accused does not have a lawyer, or if he has a lawyer, this is not a lawyer of his own choice, or he doesn't have an opportunity really to prepare a full defense. Apparently, so the right of appeal, when there was a separate anti-terrorism court, apparently there was no real right of appeal. If the anti-terrorism court were really merged back into the People's Court, it's perhaps possible, perhaps. The judges are anonymous in these courts, so they're not, the ISIS judges wore masks. And so, in theory, you could not tell who they were. Apparently, the Syrian Kurdish judges don't wear masks, but they do not publicly put their names on the decision for security reasons, for not wanting to be targeted. For groups like Human Rights Watch, this is a very problematic dimension. Human Rights Watch doesn't like Kurdish courts in general, so they don't have much good to say about them. And if you want to find a critical take on those courts, go read their reports, and you will see much to criticize there. So, there are questions of due process. Applicable law in Stychin, the Swedish court found that a rebel group could create a court, but they had to apply state law. And indeed, in the Stychin decision, they had applied the Syrian criminal code, which did provide for the death penalty for crimes like rape and murder. And on top of that, the court was composed of former judges of the Syrian courts that had gone over to the opposition. And the Swedish courts find that all of this is required for these courts to act legally. I think that it's very difficult to make an argument that rebel courts have to apply state law. There seems to be no reasonable basis in law to find that as a requirement. With relation to ISIS fighters, well, if they're accused of international crimes, war crimes or crimes against humanity, seems to be quite a solid body of law for any court to apply. So there will be little debate against that. Can they apply Turkish law? Sorry, can they apply Kurdish law? Not Turkish law. They have adopted their own laws. The Tamil Tigers had enacted their own Tamil Tiger Criminal Code and Tamil Tiger Civil Code, and many other laws. So it's not rare that the rebels will adopt their own law. The Iraqi Kurds have changed Iraqi law considerably in the Kurdish region of Iraq to, for example, eliminate the death penalty, eliminate polygamy. So is that valid? I would argue that it is, but this is an argument that is a little complicated, and I won't go into it here. Finally, what are the legal implications for the United Kingdom in essentially saying that its nationals that's what should happen, they're there, let the Kurds try them and deal with it. So in some ways, this is sort of a delegation by the UK to Kurdish entities. Well, if a first question is to say, is there here a violation of Syrian sovereignty and Iraqi sovereignty? And Iraq might be a more significant, because the British government doesn't care that much about what the Syrian government thinks, but they might care more about what the Iraqi government feels. So is there a legal argument to say that any stance that, for example, recognition of the courts of non-state entities like the Kurdish entities in Iraq and Syria, is that a violation of the sovereignty of the local state? And I think that quite clearly the argument is no. There is no violation for a country to recognize the de facto governance of a part of another state's territory. This does not meet the definition of intervening in the internal affairs of another country, and we could go to the ICJ decision in Nicaragua versus the United States, which provided that mere provision of humanitarian assistance is not a form of intervention in the internal affairs of another state. Could the UK provide legal assistance to the Kurds? So if there are shortcomings in due process, could they send lawyers to provide assistance, including possibly defense lawyers, to provide legal support before Kurdish courts? I don't think this is a ludicrous this proposition. And my interpretation of the principle of non-intervention is that this does not amount to a form of intervention that violates the sovereignty of the local state. Is there a duty to provide assistance as opposed to a mere right to do so? One possible source is the duty to ensure respect of international humanitarian law, Common Article 1 of the Geneva Convention. This is a provision that it's framed in extraordinarily broad ways. So you could read a lot into it, and many academics have written all sorts of things about what it implies. Governments have been very reluctant to agree that this means very much, and have argued against an overly broad reading of a duty to ensure respect that would require states to intervene everywhere and anywhere there's a violation of humanitarian law. So you can't make an argument that Canada has to intervene and provide support to, or do what it can to avoid violations by the Taliban in Afghanistan, for example, or something like that. But there is a difference here, because for the UK and trials of its nationals before Kurdish courts, this is not just anywhere and anybody. This is not something that has no relation to the United Kingdom. The United Kingdom has obligations vis-à-vis its own nationals under international law. And here, in a way, the trials would be happening in Kurdish Syria because of the UK's refusal to take back its nationals. Recall that the Kurds want them back, want to send them back. They don't want to try these people. And the UK is refusing to do that. Another facet of this is that the United Kingdom actually has boots on the ground in Rojava and the Kurdish region of Iraq. How many? Well, we don't know. And mostly it will be special forces kind of people, but it has a military presence, which again creates a link that opens an avenue to make an argument about the applicability of the duty to share respect and to ensure respect. I mean, this especially, for example, if the UK were to share information with Kurdish courts. If the UK prosecution service has evidentiary elements that can be shared to assist in the prosecution, well, should they do so? And if they do so, does that become a form of involvement that, under duty to ensure respect, drags the UK into taking steps to the extent that it can? A duty to secure human rights as a last element, so not under international humanitarian law, but under the ECHR in particular, as well as the ICCPR. So here there is a jurisdictional hurdle, as you may know, that the human rights obligations will apply to individuals under the jurisdiction of the state. And UK fighters detained by Kurds in Iraq are not under the jurisdiction of the United Kingdom to become applicable. As we see in the ECHR decision in Stychin, so jurisdiction is primarily territorial, but not exclusively territorial. And even though this is not in an area under UK control, this is not in the so-called espace européen that also for broader applicability, ECHR has found that a state may be under obligation if it exerts what it calls a decisive influence over a non-state group. There are decisions dealing with Russia and non-state groups controlling part of the territory of other states. A different take would be to connect this to the Syrian jurisprudence of the ECHR related to the transfer of an individual towards another jurisdiction where there might be a violation, where we could argue that the UK's refusal to take back its nationals creates a connection and renders possible the local prosecution, and that is a legal step that can open a door for an argument that the UK therefore has obligation in that respect. The UK High Court, in a decision a few months ago in El Ghizuli, refused an interpretation that's a little bit like that about sharing of UK information to the US about a British ISIS fighter detained in Syria that the US wanted to bring to the US for prosecution. So this is a more difficult argument and more ambitious, but not altogether impossible. So at the end of the day, we end up in a situation where there is a great concern for UK ISIS fighters in Kurdish hands. However terrible the deeds they have done, they are still entitled to justice. And it's in the broader interest of the international community that these individuals be treated fairly and be condemned for crimes that they have in fact committed, than to let stand a situation or a process that merely piles up another injustice on top of the injustice that we began with. So there we go. I talked for a long time.